Let us also have a written list of the documents on both sides so that we can determine the length of this trial. We have to have a time horizon because justice delayed is justice denied. If there is no objection from my colleagues, kindly consider that you have been so instructed and submit these materials within the week. Let us say within 3 days from today.
Is that a motion by the lady senator?
If it is necessary, if there is no objection, then it is the consensus of this court.
Is there any objection from let me first, to be fair, is there any comment from either the prosecution or the defense?
On the part of the defense, if Your Honor, please, we will obey or follow as suggested, Your Honor.
How about the prosecution?
May we request for 3 days to comply with that?
I have no objection.
Thank you.
Any objection from the chamber, from the members of this court regarding the suggestion of our distinguished colleague, the lady from Iloilo? The chair hears none. The suggestion which is taken to be a motion is hereby approved.
On just,
So ordered.
on just another point, Mr. President, may I be allowed to continue? I have 2 minutes.
Proceed.
The question is, what is the standard of proof in impeachment proceedings? In a civil case, the standard of proof is very low. It is preponderance of evidence. In a criminal case, it is very high, proof beyond reasonable doubt. In an administrative case, it is clear and convincing evidence. In the question at hand, I humbly submit that the standard of proof should be overwhelming preponderance of evidence. That is the suggestion of this humble judge. You may comment on my suggestion, in which case I shall ask my colleagues if they have any objection to my proposal.
May I now be heard, Your Honor, in connection with the suggestion?
Let us give the prosecution first
go ahead.
the opportunity to speak. What is the pleasure of the prosecution? May I request the lady senator to please state the level or standard of evidence needed, suggested?
What should be the standard of proof in an impeachment proceeding? It can be any or even beyond the following. And by the way, let me just interject this before I forget. Conviction or acquittal are not the only ends of impeachment. Since if you read your Constitution, you will realize the Constitution says the penalty shall not be further than removal from office and disqualification from public office. Therefore, the Constitution allows implicitly that any other penalty below removal and disqualification is allowed. These proceedings, therefore, can result maybe in a censure or a reprimand, not necessarily in a judgment of conviction or acquittal. Now may I have the comments of two counsel on what should be the standard of proof.
For the prosecution, Your Honors, the impeachment proceeding is akin to an administrative disciplinary action, wherein the penalty is could be removal from office and disqualification.
So what should be
And
the
to
standard?
that, because of that, Your Honors, the standard should be substantial evidence.
Substantial evidence. And counsel for the defense.
On the part of the defense, Your Honor, it is our humble submission that the proof necessary for conviction in an impeachment case should be proof beyond reasonable doubt. Allow me to explain, Your Honor. You will note that in criminal cases, Your Honor, even in a simple case of libel, serious physical injury, or merely malicious mischief, the required quantum of evidence is proof beyond reasonable doubt. And yet, the penalty may not exceed 6 months, Your Honor. Now, why will there be a lesser quantum of evidence required in cases of conviction in connection with impeachment case, Your Honor, where the penalty